Good evening. This is Laws 12066 Land Law. We're into week 6. Now, I should explain that we're dealing with week 7 material this week and next week, possibly even going into the third week on leases. We'll then return to the week 6 material, which deals with perpetuities primarily, and from there we'll go back to the course, the unit as it's written. But leases is a fundamental area. It is directly relevant for your second assessment piece, and because it's on the second assessment piece, you might be tempted to think it's not on the examination. All I'll say is it may well be. It's always odd, isn't it, when a lecturer says it may well be, when you know that the lecturer knows what's on the exam. It's not like, children asking their parents a question and the response comes in, "We'll see." And the children know that means no. They sometimes call it as no. But when I say we'll see, it might be on the exam, that's what I mean at this stage. So no, nothing beyond that. Now, Emma, do you have a question about the second assessment?
Yeah, thanks, John. I just, not working in a law firm, I'm just curious for an example or a template of what a memorandum of advice would look like within legal practice. So I think the second assignment is where the first year law, like straight out of university, I'm supervisor, and I'm not just quite sure how to structure that.
No, that's great. Thank you, Emma. Because this is an internal memorandum, there's no particular form, and all I'd really ask is that you follow the basics of ensuring that it's consistent throughout the document. You do use footnotes, so still follow the AGCL. Make sure that it's paginated. I think those of you that have worked with me in the past, I don't like it if there are no page numbers included. And you can put a cover sheet if you like, but you don't have to. So it is a relatively informal document, but I'd like you to present it in a professional manner as you see fit. So there's no prescribed form, but on UCrew, I'll upload something that might be useful for an advice to a client, and you can use that or you can tone it down a bit as you see fit. So don't be too concerned about the format, but if you have a particular look that you think is both professional and engaging, then feel free to use it. And also, please feel free to share templates on UCrew. I hope that answers your question, Emma.
Yeah, that's great. Thanks, John.
All right, thank you. Okay, now, tonight we're dealing with leases. This is very much, I think, the heart of a law degree. And I appreciate that some of you, perhaps even many of you, won't practice as lawyers. And I do apologise in the sense that the questions that I ask put you as if you are in a law firm. But I think when you're reading cases, when you're considering legislation and commentary, it is appropriate, whether you're going to practice or not, to properly test you, to put you in that situation where you are asked to explain yourself. And I think using that format of you're a first year lawyer and you've got to explain something to a partner means that you can pitch it at a certain level. That is, you don't have to go into the basics. And I guess in some ways, I'm giving you some advice now about the second assessment. You don't have to pitch it at basics. So you don't have to tell me what the elements of a contract are if your question relates to leases, for example. You can assume that I know that type of thing. So that's the reason that I pitch the question in the format that I do, and I hope that makes sense. So leases at the heart of a law degree. And for those of you that won't practice, it's still going to be very useful because all of us in some way or another are likely to have some dealings with leasehold interests. One book that I've been using increasingly often, and for some reason I resisted this, but this is the Oxford Australian Law Dictionary. It's the 3rd edition. And if you're looking to buy something that's a valuable resource, I'd recommend that. It's put out by Oxford University Press, unsurprisingly. Now, the Oxford Australian Law Dictionary defines a lease as an interest in land that is of a certain duration or term and confers on the grantee at common law the right of exclusive possession of the interest. The case that we always cite is Radich, R-A-D-A-I-C-H, against Smith, 1959, 101 CLR 209. The term lease, according to the dictionary definition, covers both the right, which is the chattel real that is the subject of the lease document, and the piece of paper evidencing the right, as in the usage signing the lease. The grantor of the lease is known as the landlord or the lessor, L-E-S-S-O-R, and the grantee is known as the tenant or lessee. Coming back to that definition, when we talk about a lease, then we're talking about two things, but essentially evidencing the same thing. The first is the document, the lease document, and the second is this right to occupy premises exclusively for a period of time. We also call that your lease. I hope that makes sense. And I will use the terms landlord and lessor somewhat interchangeably, but the legislation tends to refer to the grantor of the lease as the lessor, so I will try to use that terminology. And the grantee is the tenant or the lessee. I will try to use the term lessee, but please excuse me if I fall into some error in that regard. Now, leases. A few different ways you can categorise them. You can categorise a lease by the type of document, by its duration, by its method of change, or by interest. There's possibly more, but they're the ones that I could come up with. So categorisation by type. The first is that land tenure may be a lease under the Land Act. In Queensland, Western Australia, various parts of Australia, there are large tracts of land that are in fact leasehold interests, leases from the Crown. That's through the Land Act. We won't be dealing with that a lot in this unit. The next type is a commercial lease. So I'm categorising them by type now. A commercial lease is of two types. So the first is commercial lease excluding retail shop leases. And the second type is commercial leases that are retail shop leases. The fourth category of lease is a residential lease. We won't be talking about those a lot in this unit. So you rent a house, you rent a unit, you sign a lease for 6 months or a tenancy agreement for 6 months, 12 months. I'm not going to be covering much of that. And so most of the unit will be therefore dealing with what I call, and I'm just using this term broadly, commercial leases, either retail shop lease or not retail shop lease. I'm going to contrast leases with licenses, and we'll talk more about licenses later. So that's the categorisation of leases by type. Categorisation by duration. Typically, when we're talking about, say, a commercial lease, it's for a fixed term, usually in years. It's not very often that we have leases in a commercial context in months. A 3-year lease is very common. 5 years is very common. Less common, but still prevalent, 10 years, 20, 25-year leases. We don't see many that go beyond that, but it's conceivable. Periodic lease is the second categorisation by duration, and that's from one period to another. So you might hear these terms, a lease year to year, or a lease month to month, etc. So that's a categorisation by the duration. We won't be talking a lot about that. Other types of duration, tenancy at will, tenancy at sufferance, we won't be talking much about that. So primarily in this unit, we're talking about commercial type leases relative to a fixed term. I just need you to be aware that there are other variations. We just don't have time to deal with them all. There is another way that you can categorise the duration in a, if I can use the term, commercial lease, and that is when we talk about the original term versus the extended term or the option term. So typically in a commercial lease, the tenant, I've done it already, the lessee will have a tenure for the premises for a certain number of years, let's say 3, and often will have the right to exercise an option to extend for a period, and usually the period of the extended term matches but doesn't have to match the original term. And sometimes we describe that as a 3+3 lease, or a 3x3 lease, or a 3+3+3, or a 3x3x3. Does that make sense? So you'll hear that shorthand time language. So the original term versus the extended term, I guess, is a different way of categorising the duration of the lease. The third way to categorise leases would be by reference to the method of changing the lease. The assignment of lease is one way, and it's, if you like, someone taking over the lease. We call that an assignment of lease. It doesn't create a new lease. It simply means that someone has taken the benefit as lessee of that lease. Second method of change is a transfer. Now, you often hear of an assignment and transfer within the same context or the same effective transaction. And the reason is that the assignment of lease is usually a document which is done by deed. So we talk about a deed of assignment, as opposed to the transfer, which is talking about the registrable instrument lodged at the Registrar of Titles office, which causes the registrar to change what's on the title. So you can gather from that that it's possible for a lease not to be registered on the title, or it may be registered on the title. It's possible for someone to take over the lease by way of accepting an assignment. That may or may not be on the title. That'll be by a deed. And if there is a registered lease, then you would expect the transferee, the new lessee, to take a transfer and be registered as the new lessee on title. Am I going too quickly, or are you following me? All good? All right. Another way of changing a lease is by what we call surrender. Surrender is cancellation of the lease. And often a surrender of lease is coupled with a fresh lease. So it may be that instead of affecting an assignment/transfer, the way in which we have someone new take over is to effect a surrender coupled with a fresh lease. I'll come back to that shortly. Yes, Monique?
Can either party surrender a lease, or can it only be the lessee?
In fact, it has to be by consent. So it will be always both parties. In other words, one will ask the other for a surrender, and then the other must consent to it. So typically there's no right in a lease document, in a commercial lease document, for one party or the other to effect a surrender unilaterally. It may be, but it's not common. So usually that's by consent. Another way of looking at the categorisation by method of change is by reference to the assignment of the reversion. Now, when I was talking about the assignment of the lease, I was looking at that from the perspective of the lessee and the new assignee taking over the lease. An assignment of the reversion is where we have a change of owner. The lessor has changed. And that will usually be accompanied by two documents: a transfer, which is the registrable interest instrument noting that the registered owner has now changed, and an attornment notice, ATTORNMENT. An attornment notice is really nothing more than a notice, a formal notice to the tenant. I really do prefer landlord and tenant. You can tell that, can't you? To the tenant saying, you now have a new landlord, or to the lessee, you now have a new lessor. Does that make sense? All right. Another terminology that's referable to change is a forfeiture of the lease, which is where the lessor retakes possession of the property. So it's a bit like a forfeiture in a mortgage situation. Okay, so they're different ways to categorise a lease by reference to a change in the documentation. I'm just going to take a break for a moment before I get into categorisation by interest and just raise with you an issue as to why we consider, on the one hand, from the tenant's perspective, an assignment of the lease as opposed to a surrender coupled with a fresh lease. You might think, well, they serve the same purpose. They serve the purpose of someone new coming in as the tenant. Why would you have one over the other? Different rent, says Kathleen. Yes, that's a good point. So a fresh lease may mean that either for the benefit or the detriment of the lessor, there's a new lease rental paid. Different terms, option periods. Thank you, Sarah. That's good. What else is there? Continuation of the term, says Monique. There may be other terms to negotiate or break lease fee, maybe. The length of the term, adding other parties. Good thoughts. Okay, so you've got a really good idea there that where you've got an assignment of the lease, typically it means you take the lease as it is and the new person takes over. Now, not always. I've said typically because sometimes on an assignment of lease, we have the parties take the opportunity to add extra clauses, like add an extra option. So they might do that. So an option, even a further 2 or 3 options might be added in as part of the deed of assignment. So that might be negotiated. But there's another fundamental reason why, as a tenant, a lessee, you might particularly be interested in a surrender as opposed to an assignment. And it all goes back to contract. So bear in mind that a lease interest is both a contract and an interest in land. So by effecting an assignment with a transfer, you are transferring the interest in the property, the REM component, but you're not transferring completely the contractual term. In other words, if you have an assignment of a lease and the assignee, the new lessee, goes broke, then the assignor, the original lessee, can be held liable under the terms of that lease even though they transferred to somebody else. Now, that won't apply if the new lessee has gone into an extended term. So I'm really talking about the term during which the assignment takes place. So you have a 3-year lease. After 1 year, the lessee sells the business, somebody else comes in. At the end of the 2nd year, that person goes broke. Out of the blue, the first tenant, who's now, living at Byron Bay and living the high life, gets a bill for 12 months rent for the 3rd year because the person to whom they sold has gone broke. So from a tenant's perspective, from a lessee's perspective, it might be beneficial to effect a surrender by consent, which will have the effect of, if you like, cancelling, nullifying that lease so that they're off the hook into the future. Conversely, of course, if you're acting for a lessor and your lessee comes to you and says, I've sold my business, I'd like a surrender, and you can have a fresh lease with the new incoming occupier. Why do you think you would, if you're advising the lessor, do you think you'd think that's a good idea? Is there any downsides for the lessor? Looks like I've stumped you on that one. May not know the business conduct. They may want to renegotiate the terms. Yeah, there's those things. The fundamental issue for a landlord, for a lessor in those circumstances, is this. If the lessor does consent to a surrender of the lease and enters into a fresh lease with the incoming tenant, the problem is twofold. The first is that if the new incoming tenant goes broke, having surrendered the old lease, they can't chase the original tenant. So generally, a lessor would say, no, I'll consent to an assignment, but I'm not going to consent to a surrender. If the new person goes broke, I'd rather have the insurance of being able to chase you down the track. And the second reason that the landlord, the lessor, might prefer a surrender, so it might prefer an assignment, is because of legal fees. It costs more to effect a surrender and have a fresh lease than it does typically to assign the existing lease. So it's a couple of reasons why a lessor might not be too keen on that. Any questions about assignment, surrender, transfer, assignment of the reversion? All good? Okay. Now, in terms of leases, there might be differences in categorisation by interest. Old system title, we have leases. There's not much old system title around anymore. So predominantly it's Torrens title, and that's what you can expect I'll be concentrating on in this unit. So you've gathered so far that for the most part in this unit, when we're talking about leases, I'm talking about what I call commercial leases. I'm talking about fixed term leases and Torrens title leases. But there are variations as well. Categorising by interest, the lease might be a legal interest, it might be a legal interest, or it might be an equitable interest. It might be an unregistered equitable lease in Torrens title. It might be an unregistered legal lease in Torrens title, Torrens land, or it might be a registered legal lease in Torrens land. Now, if you're a keen listener and reader, you might be thinking, hang on, how can you have an unregistered legal lease? Isn't that one of the hallmarks of an equitable lease if it's unregistered? So firstly, how can we have an unregistered equitable lease? What do you think would give rise to that scenario?
John, it's Monique. Sorry,
Yes, Monique.
I had thought about what was your first option? The unregistered legal.
No,
lease?
I'll go through three.
Okay, sorry.
So
I had an answer for that one when you're ready.
Sorry. So number one, unregistered equitable lease. Number two, unregistered legal lease. And number three, registered legal lease, all in Torrens land. So Kathleen, so the first one is, what's an example, or how could we come up with an unregistered equitable lease? Unregistered equitable lease in Torrens land. Unregistered equitable, not registered, says Kathleen. Yeah, what type of not registered? By part performance, says Monique. Yes, I agree with both those, potentially. So if we have a lease which ought to be registered but it's not, then arguably we have either a lease which is illegal because it doesn't comply with the Land Title Act, or more likely it's an equitable lease. Or perhaps it's a lease that parties intend to register but actually hasn't happened yet. So that might give rise to an unregistered equitable lease. Greg says, yep, agrees with that. What about an unregistered legal lease? And I can see that the answer was provided earlier by Kathleen a little while ago. 3 years or less, unregistered. Yep. So if we have a short-term lease, which is 3 years or less, in Torrens land, it can be both unregistered and at the same time legal. And a registered legal lease, of course, is one which is registered on title. So conceptually in Torrens land, as we know, a legal interest is created through registration, which then confers indefeasibility. but we'll recall the exceptions to indefeasibility, and one of those is the existence of a short-term lease, albeit unregistered, still has the benefits of indefeasibility, even though it's not registered. I hope that makes sense. But an option to purchase the property contained within such a document is not an incident of the lease or integral to the lease, and the option to purchase the property does not derive indefeasibility. An option to renew such a lease arguably does, but that's an area where it's a bit more specialised. If a lease does not satisfy the formal requirements for the creation of a legal lease, it may have effect as an equitable lease. And the hallmark is this: if it's specifically enforceable, then it's equitable. Really, that's the cart before the horse, really, isn't it? But Walsh and Lonsdale is the case that you need to consider in that regard. That's the authority, 1882, 21, Chancery 9. But bear in mind, of course, that under statute, an agreement still needs some memorandum or note in writing, signed by the parties to be charged, or signed for or on behalf of the party to be charged. So Walsh and Lonsdale was the parties entered into an agreement for lease. The tenant went into possession and started paying some rent. So you've got the picture so far, and this is along the lines of what Monique was alluding to earlier in the chat facility. The formal lease was not signed, even though it did provide for rent 1 year in advance, and the court held that even though there was no formal lease, equity would still enforce the agreement according to its terms. So that's the rule in Walsh and Lonsdale. It applies in general law and to Torrens land, but third-party obligations under an equitable lease may be unenforceable, and the case there is Chan against Cresden. We talked about that previously. That's 1989, 168 CLR 242. So if you have to answer a question in an examination or a take-home paper about different types of leases, equitable leases, legal leases, just bear in mind a couple of those concepts, Walsh and Lonsdale, and draw some distinctions. Always keep in mind the effect of sections 11 and 59 of the Property Law Act. We dealt with these at length in conveyancing last night, for those of you doing conveyancing. And remember, of course, if you're really keen, you can always look at these videos in different subjects. They're all on the internet. So section 11, Property Law Act, have a look at that. Instruments required to be in writing. So no interest in land can be created or disposed of except in writing signed by the person creating the interest or the person's lawful authorised agent in writing. Section 59 is a bit different. Section 59 says that no action may be brought on a contract unless the contract for which the action is brought or memorandum of note in writing is signed by the party to be charged. So section 59 deals more with enforcement of a contract for the sale of land or for the disposition of an interest in land. So section 11 talks about creation or disposal. Section 59 talks about contracts for the sale, and it's to do with enforcement. So I think you need to keep those two sections in mind in any answer that you give around leases. A useful add-in under most circumstances. Now, you need to, of course, consider the Land Title Act within the context of leases. We've dealt already with sections 184 and 185, and tonight we've already talked about indefeasibility and the exceptions to indefeasibility. In talking about the exceptions, have a look at section 185, 1B, which talks about the interest of a lessee under a short lease. as being an exception to the indefeasibility benefits which are conferred by reference to Section 184 of the Land Title Act. All good? It's an important concept, and you need to be able to cite that piece of legislation if you're asked to draw a distinction between a short lease and a lease that's not short. I won't say a longer lease because we don't have a definition for the longer lease. Where do you think you'd find the definition of a short lease? I've mentioned that it's Section 1851B of the Land Title Act. Where would you go looking for a definition of a short lease? Section 4, says Scott. The definition sections, says Monique. The Land Title Practice Manual, says Greg. Very practically orientated there. Schedule 2 of the Land Title Act, says Karen. Yeah, I picked up on that, Karen. Schedule 2. All right, I'm going to give the gold medal to Karen on that one. So have a look at Schedule 2 of the Land Title Act. Short lease is specifically defined, and it means a lease for a term of 3 years or less, or from year to year or shorter period. So a short lease is a term of 3 years or less, or from year to year or shorter period. Okay, so we've got that. Yes, Monique?
John, if you've got a short lease that also has an option but is unregistered, does that fall within the definitions of a short lease or not?
Excellent question. That's an excellent question. It's still a short lease, even though, so you may have a 3 + 3 + 3, it's still a short lease. If you have a 3 + 4 + 3, which would be really weird, and we just don't see it in practice, then you potentially have a long lease for the middle part and short for the first and the third. But we just don't see that in practice. All right, so you need to remember that and be able to refer to what is a short lease. Now, I mentioned there's a distinction between leases and licenses. Again, I'll go to the Oxford Australian Law Dictionary, and it defines license in 3 ways. The first, a contract under which the person, the licensor, grants consent or permission to another person, that's the licensee, to do something in relation to the licensor's property, real or personal, that would otherwise be a wrongful use and give rise to an action in tort. So under the first way of defining a license, it's allowing somebody to do something with your real estate or your personal property, which if you didn't have that permission, would give rise to the landlord or the owner of the property being able to say, you have committed a tort against me. That's what the first way. The second is, now specifically in relation to real estate, a license permits entry upon land or use for some purpose that falls short of a full right of occupancy. So unlike a lease, a license is not a proprietary interest that includes an assignable right, it's merely contractual. And this is probably what we mean by a license typically. It means that you have some ability to enter onto the property, you have some ability to use the property for some reason, but you do not have the full right of occupancy. It's the full right of occupancy, it's the right to exclusive occupation of the property that is the hallmark of a lease. So a license is short of that. The third way to categorise a license is that of a statutory license, which authorises something that would otherwise be prohibited by law. So we see that the main right conferred by a lease is the right for the lessee to enjoy exclusive possession of the leased property. That's the key feature and the key difference between a lease and a license. And the categorisation is important because the remedies that are available to the aggrieved party will be affected as a result of that, and it will likely also mean that you have different court or tribunal to consider. I'm not going to be talking much about licenses in this unit. So a lease, as we've heard, confers property in the lessee. It also involves a contractual arrangement. It's a proprietary interest that is assignable, but just coming back to an earlier point, bear in mind that the assignment is usually subject to a term of the lease that says that it is subject to the consent of the lessor. And we usually say, however, the consent may not be unreasonably withheld. All right, are we all good so far? We're keeping up? I know we're covering a lot, but it's a big area. Reversionary estate. Well, we know the reversionary estate is that which is retained by the lessor in the leased land after the lease comes to an end. So given that the hallmark of a lease is to allow the lessee exclusive possession, it means that for a period of time, the lessor doesn't have the right to go onto the property, has to have a contractual or statutory right to do so, does not have the as of right ability to just simply wander onto the property. So whatever's left after the lease is finished is what we call a reversionary estate. And you might see that often in a will. You might see someone confers upon another person a life tenancy, and then we talk about the reversion, what happens after that life tenancy or tenancy comes to an end. Okay, now Greg says, according to the index, all licenses are covered in Chapter 1, except the case at Chapter 8.22, Radich and Smith. Okay, so thank you for that, Greg. So coming back to some terminology, we talked about assignments. So I think we know what an assignment is. One that I forgot to mention was subletting. So you'll hear sublease or subletting, and generally both have a rider that the consent of the landlord may not be unreasonably withheld. Can anyone give me, just conceptually now, examples of two types of a subletting? I hope that makes sense. It's probably a bit obscure. So if you think about a sublet, what immediately comes to mind? Let's say someone has leased an industrial shed for 10 years and the tenant says, I want to sublet. What does it mean? So Emma says, where a tenant rents a room out of a house. Okay, so what we're saying is we're using part of the property as the object of the subletting. Yep, that's one of the two that I was thinking of. What's the other one? Bear in mind that with a lease, I've said you've got a lease of a property for a term of 10 years. So if you let some of the property, that's a subletting. If you let some of the term, that's a subletting as well. Let out for a shorter period. That's exactly what I was after. Thank you, Amanda. And Greg says, in an industrial estate, land is subleased at times to store material, as an example. Yes, so part of the property. And Monique says less than the full term. Okay, so when we talk about a sublease, you can see that it may be one of two, or perhaps both circumstances. Now, I've mentioned option to renew lease. Do we all know what an option is? What's an option? Yes, Monique?
Is it a right that the lessee has to extend the lease for the specified term?
Yes, yes. So an option to renew is something which is conferred upon the lessee, entitling the lessee to give notice to the lessor of an intent to extend the term beyond the original term, to take up the option, we say. And that period of time, the option period, will be defined in the original document. And typically a 3x3 lease, for example. So it normally requires a written notice, and usually a lease will provide that it must be given not less than a period before the expiry of the term. 3 months is pretty common. So you'll see that very often. Something to the effect that the lessee has an option to renew the lease for a further period of, say, 3 years by written notice to the lessor, given not less than 3 months before the expiry of the lease. So what that tells me is if you're advising a client, you really do need to stress the importance of being aware of the date for exercise of an option, because usually time is of the essence. You miss the date, conceivably, you lose your entitlement to exercise that option. You can give late notice, the lessor can accept late notice, but the lessor would not be obliged to accept the late notice. Now, when exercising an option to renew, the lessee will need to know what the new rent will be. And here's the rub. For the lessees, they usually don't know. At the time that they exercise their option, it won't necessarily be the case that they know what the rental is. Now, some leases provide for a mechanism or even a dollar figure as to what the rent will be on the first year of the extended term. I hope I'm not going too quickly. You can follow what I mean by the terminology. But most often, a commercial lease will provide that the rent payable by the lessee for the first year of the extended term will be something. What's the something that I'm getting at? CPI, says Sarah. Yes, can be market value. That's even more likely. Fair market rental or fair market value. So what that means is this. If you've done an extremely good job as a lessee in negotiating a lease on favourable terms, 3 years with a 3-year option, and you've got your business up and running, and at the end of the 3rd year you decide to extend your term, you exercise your option, suddenly, instead of paying $30,000 per annum for your rental, which was really cheap, for the first year of the extended term, you find that you're called upon to pay $50,000, way beyond CPI. Perfectly lawful for the lessor to do that if the rent for the extended term is made reference to a formula such as fair market rent. Because from the landlord's perspective, essentially you've been getting a discount of $20,000 a year for the first 3 years, and now it's time to pay the real rent, the market rent. Does that make sense? So if you're negotiating as a tenant and you have a very good deal and you're confident it's a good deal, you want to try to go as far as you can. In an extreme circumstance, you might say, well, this is excellent. I'm very confident I'm going to sign a 10-year lease, or I'm going to sign a 15-year lease or a 20-year lease. You see what I mean? Or if you're going to have a series of options, try to build them in a mechanism that gives you some degree of certainty. And of course, it's converse for the landlord. It works both ways. So there are different ways that the rental for the first year of the extended term might be determined. Market rent is the most common. It might be CPI, or it might be a fixed rate of increase, say 5% per annum, or there may be no increase at all. It might just be a flat fixed term through the term of the original lease and the extended term. But usually you'll find a lease will provide for maybe CPI through the term of the lease, and then a market review for the first year of the extended term, and then we go back to CPI, let's say. I know I'm moving fast, but any questions? Monique says, is there any legislative principle, is there any legislative provision for that principle? That's a good question. Generally, no. It's generally something which is done as a matter of course. It's a commercial, if you like, reality and a commercial custom. But I do want you to be aware of Section 27A of the Retail Shop Leases Act 1994, and that provides a tenant, a lessee, with an extra opportunity that a lessee in a non-retail shop lease does not have. Section 27A allows a tenant, a lessee, to require early determination of the current market rent so that there is some further certainty for the tenant before having to commit to the 3 years or 5 years. But in fairness, that also applies to the lessor. So the standard rule is no, it's a contractual thing, but if it's a retail shop lease, bear in mind section 27A. I hope that answers your question, Monique. Yes, Monique?
It does. Just a further question on that then. If a lessee wants to invoke 27A, does there need to be a specific term in the lease that states that it needs to be reviewed at market value?
I don't believe it is. I think it's the statutory provision overrides anything in the contract, and I think the statutory provision, but have a look at it, I think the statutory provision provides for the mechanism by which the determination of current rental can be made. There is a little trap when it comes to determining values for retail shop leases, and that is that there is a bank of specialist retail shop lease valuers, and you must use a specialist retail shop lease valuer when determining the rental for the extended term, as opposed to a non-retail shop lease where you can use a valuer who is not accredited as a specialist retail shop lease valuer. Does that make sense? Sarah, did you have a question?
Yeah, I do. I was just wondering, with regards to them being able to obtain how much it was going to be with market value, would that change if they were to say have exercised the option? Can they still use that provision to make their decision as to whether or not they want to stay after they've been told how much the rent's going to be?
You're talking about a retail shop lease in section 27. Look, I'll need to check the section again, but my understanding of it is that it provides a mechanism where the tenant can find out what the rent would be and then make a decision. Now, that's relatively new. So when I was practicing as a solicitor, we didn't have that provision, but I believe it's there now as a new provision. So it takes away some of the uncertainty.
John?
I'd like you to have a look at that because I might be wrong. I don't think so, but I might be wrong. Yes, Karen?
I'm just looking at 27A subsection 6, I think is what it's going to refer to. Despite any other provision of this Act or the lease, the last day on which the option mentioned in subsection 1, which is the option to renew, may be exercised is the day that is 21 days after the lessee receives written notice of the current market rent determined under this section.
Excellent. Thank you, Karen. Great. That's excellent. So the tenant does have that option to consider 21 days to do so. Thank you, Karen, for answering Sarah's excellent question. Yes, Monique?
Sorry. So that could be in effect after the date in the lease, potentially.
Potentially, yes.
Yeah. Okay.
Potentially, yep. In which case, the terminology that we use is that the lessee is holding over on the lease. All right, you're all doing very well. Can we push on a little bit more? Thank you. Questions, but just to see if you're hanging in there. Now, what we've been talking about is an option to renew the lease. Bear in mind that there are different things, different terminology that mean different things, but they kind of sound a little the same. One is an option to purchase the property. I guess you could pretty obviously see the difference between an option to renew the lease and an option to purchase the property. Just bear in mind that you may need to consider the Duties Act if you incorporate an option to purchase the property, because that may become dutiable from the outset. So I'm not going to give specialist duty advice, but just be aware of that possibility. And another variation is, if you like, an option of first refusal or preemptive right. Do we know what that means? If a lessee has an option a right of first refusal. Essentially what that means is that if the landlord wants to sell the property, then the landlord would be obliged under the terms of that contract to offer the property for the tenant to acquire first, and the tenant, the lessee, has the right of first refusal. If, having put the proposal to the tenant, the lessee says, no, I don't wish to acquire the property, then of course the lessor is free to sell the property on the open market. But it's, yeah, Scott says, giving the lessee the first bite. That's exactly it. So that's what I call a right of first refusal or a preemptive right. Okay, and it does need to be in the lease. There's nothing in the legislation that grants to a lessee an entitlement at law, so it's a contractual thing. So when you're dealing with issues to do with rights and responsibilities, that reminds me that you need to consider the terms of the lease, the statute or statutes, and the common law. So if you have a lease problem in an examination or take-home paper, you must identify the fact that even though it hasn't been mentioned in the paper, you must first consider the terms of the lease document. And it may be that your answer says something like, I haven't been furnished with a copy of the lease document. I will assume that the lease does not contain this, or I will assume that the lease contains that. There's nothing wrong with that. That's a perfectly legitimate approach. If as an examiner I have chosen not to give you this information, which you would normally expect to be given, call me on it. So I'm on to you, I'm calling it, you should have given it, you haven't given it, so I'm making an assumption one way or the other. And if you make the assumption one way or the other, I can't say you're wrong, can I? So if you say, I assume that the lease contains an option, I can't say you're wrong. I mean, it might depend on the context of the question, but I hope you understand what I mean. So terminology, I think we've dealt with mostly. An agreement, we haven't dealt with agreement to lease. Does anyone know what an agreement to lease is, as opposed to a lease?
Is it a contract that you intend to enter into a lease in future?
Yes, exactly. Now, why would you do that? Why wouldn't you just sign the lease?
Maybe there's no property to actually lease.
Exactly. Monique said it just as Kathleen said, it's being built. Exactly. So if you've got an interest in going into a shopping centre and you wish to take up one of the original tenancies, you would expect to be offered to sign an agreement to lease, and in that agreement to lease would be attached the lease itself. And I guess that's another example of an equitable lease, isn't it? Through part performance also. So an agreement to lease is in those circumstances typically. And Greg says, specialist valuers are available at this website, specialist retail valuers, download list of specialist retail valuers at http://vrbqueenslandqld.com.au. Thank you very much, Greg. That's excellent. So that's an agreement to lease. We know about that. We know about an assignment to lease. We know what a sublease is. We know what a transfer of lease is. We know what a surrender of lease is. We know what a forfeiture of lease is. So we've got all that. Another thing you might hear sometimes is termination of a lease. And this is to do with repudiation. I'm getting a bit fancy now. Does anyone know what repudiation means? And I've got to say, I've got to be a bit careful here because it is actually used in two different ways depending on who you're talking to, but there is, like when I was doing law school, it was 50-50. Now it's really one way. So what's a repudiation? You'll hear that in terms of contracts and leases generally. What's repudiation? Okay, Monique says unilateral termination. Kathleen saying the lease is invalid. It's a legal ability to get the lessee out, says Greg. Yep. I think it's something which basically has the effect of saying, I'm not going ahead with this. So that's a repudiation. And the other side, not abiding by the contract, says Scott. That's it. So for some reason, no, not necessarily a good reason or an arguable reason, you say, I'm not proceeding. So the other side can then say, you have repudiated the lease. I am now terminating the lease based on your repudiation of it. So it's a contractual thing. The case that we always refer to, and you've really got to write this down, if you're dealing with repudiation, termination, always cite Shevill, S-H-E-V-I-L-L, against Builders Licensing Board, 1982, 149 CLR 620. I'm just going to push on with one last concept, which means that next week we can start with our further in-depth discussion of the Property Law Act, and then I want to move as quickly as I can onto the Retail Shop Leases Act. So the last thing that we're going to do tonight is just briefly leasehold tenure under the Land Act. I mentioned that we'll just touch on it. I won't go in too far. Have a look at the Guide to Land Tenure under the Land Act, 1994. It's an excellent publication. It's put out by the Department of Natural Resources and Mining. So DERM, is that how we say it these days, Sarah? Is it still DERM? Still DERM? Okay. And freehold, of course, is the most complete form of land alienation from the state, but you may have a leasehold interest, which is less than freehold, but somewhat similar in the way it feels. So a lease under the Land Act might be for 1 year, but more likely 100 years. So we're talking a really long-term lease. It can be perpetual. It might be capable of freeholding. Okay, so it was DERM and now it's the DNRME as the name has changed. Thank you, Jessica, and thank you, Gregory. So I'm a little out of touch. But I think we still call it DERM. So, yep, still refer to it as DERM, says Sarah. Yep, Jessica agrees. Other things, you might see that the leasehold interest is capable of freeholding. So sometimes you can pay a fee to freehold a leasehold interest. You might also have road licenses or permits to occupy. All right, so, and remember, of course, section 185, which talks about indefeasibility for short leases. And remember, as I think it was Karen reminded us to look in the schedule for the definitions. Okay, so that'll do us for tonight. Are we all good? Everything fine? Any questions? Yes, Scott?
Yeah, just one question, John. Earlier in the cheat, you talked about there was a difference between, I understand the difference between option to purchase property and the option to renew the lease, but you said one could do something whereas the other one couldn't. I couldn't remember whether it was one was enforceable or...
Yes, okay, no, that's a really good point. So just to clarify that, if you have a short-term lease, I'm sorry, no, if you have, I've just got to be careful of this. In terms of indefeasibility, what I can say is that an option to purchase the freehold is not regarded as touching upon the land, and therefore it does not survive issues to do with indefeasibility. It doesn't have indefeasibility. Whereas an option to renew the lease does have the general protection of indefeasibility because the courts say it touches upon the land itself. I hope that makes sense. Okay, thank you, Scott. All right, all good? So we'll end the session for tonight. So next week, we're going to start with the Property Law Act. Please read ahead, and I'm going to ask you to please read the Retail Shop Leases. So the main focus of the next part of the unit, Property Law Act and Retail Shop Leases Act. So really have a good read of those. Okay, all the best. We'll see you next week. Bye then.
John?
Oh, sorry, yes. Yes, Karen?
Question. So what study guide should we be looking at?
Just 7.
Still on 7.
Still on 7. Yep.
Okay.
And then we'll come back to 6 and then I'll move on to 8. But I'll probably move through 8 fairly quickly to get on to 9 and 10. Okay. All right. All the best. We'll see you next week. Bye then.